helpful. This is LAWS12066 Land Law, and we're looking at topic 7 on leases. Grant, did you want to say a little bit more about that thought you had in terms of your experience with contract and that sort of thing?
What I was saying is that having had past experience negotiating commercial leases, including warehousing and facilities and the services that go with it, I'd never considered the proprietary aspects of it, and I'd never encountered any discussions or need to discuss the proprietary aspects of it. It has always been just purely contractual terms, negotiating from a viewpoint to try and get the best terms that you can, not just in terms of the rate, but in terms of other services and conditions. So this chapter was particularly challenging because what I thought I had a very good understanding of, I suddenly felt out of my depth, not knowing what I was reading. It was it made me look at it from a very different viewpoint.
Yeah. The other thing, I mean, that's interesting from both of those perspectives, and that's a really great benefit of having, in my view, from my side of the table, having students like yourselves, that it's a different dynamic, a different learning dynamic, because you are bringing different experiences, either commercial, business, life experiences, into your response to the framework of material. Just going back briefly to Lisa's point, look, it is abundantly true that this is a very challenging topic. Course in terms of area of law that is something that one has to do in one's law degree studies. And the other thing too, which is interesting, is that a lot of the framework of the law doesn't necessarily factor on a day-to-day basis when one's out there in practice. And what Grant has said with regard to the negotiation of commercial leases and maybe even retail shop leases and so on and so forth is an indicator of that. For those of you, not all of you, but some of you doing conveyancing with me, you'll know that the transactional process has a very practical orientation to it. And some of these property law ideas and some of these property law features and characteristics that we're delving into, which, as we know, are informed by both legislation, which is at times a bit complex, body of case law dealing with common law, and also equity, it is challenging. And also the great, great sweep of legal development that is here, even in this topic in leases. And you'd think that not Lisa, but leases. You would think that this is something that is very practical and very current and very modern. But even here we see that we're casting our gaze back to even to the 12th century to see where the origins of the leasehold interest derives from. I think it's Aisha who has mentioned a couple of times in a couple of places I've seen keep referring to leases as chattel's real. Look, I really would disabuse you of those arcane technical ways of expressing legal interests. That was a classification. I mean, technically it still is a classification, but there is a language and a nomenclature now which is much more, in my view, appropriate than to try and go into those old classifications. So that's just a comment, Aisha, on a couple of things I've seen you pop up with regard to that idea of classifying leases. It's better to talk about them in broad proprietary terms or contractual terms rather than going back into that more technical, formalistic way of categorising things. Did you want to say something there, Aisha?
Yeah, I did. I wanted to comment on something that Grant had mentioned before about going into commercial leases.
Yep.
And I've entered into commercial leases as well.
Mm.
And some of, I didn't realise when I was reading through that commercial lease, which was a couple of years back, I didn't even understand what they were talking about when they said, you know, is the lease going to be registered? So doing this and aspects of property law and things like that is interesting, because I hadn't sort of known any of that before.
That's right. And getting back just before we get into the substance of today's class, the Grant's point, you know, about the negotiation. But then, if it's a lease of a certain duration, and commercial leases are very typically of a totally different duration dimension to residential leases, for example. And, you know, as we know, residential leases, for example, are dealt with differently. But commercial leases are of a totally different duration. And the legislation, of course, talks about, 3-year leases and registering the leases. And then by registering, of course, in Torrens land, they get the protections of the legislation and so on and so forth. But commercial leases, particularly, for instance, large lease, commercial leases over large areas of land or shopping, sort of commercial buildings, not even, that aren't subject to the retail retail shop leases legislation, but in commercial buildings and so forth, they can be, 5-year leases with options to renew, renew and a couple of times, and because the landlord is really just this is an investment from their point of view, and they just want, at the end of the day, they want a tenant in, and they want, continuity of rent. But the other thing, of course, with the commercial premises, and not so far away from where I'm located, I've been noticing past an area where there's a redevelopment taking place of a commercial building. And when a business vacates, or a commercial lessee vacates, and another one takes up a lease, they very often have a different business, and so they want to do things with the building. It might involve knocking out walls, it might involve reconfiguring spaces, and that's quite a bit of investment from the lessee's point of view. And so they're not in there just for a few months and then out they go. They want to stay around for a while, and that will be part of the negotiation of their lease. But their lawyer representing them should also be clearly explaining to them that this is going to give you an interest, a proprietary interest, a leasehold interest, and if it meets the test with regard to duration, that was going to be registered under the Torrens Act, and that also brings other protections. This really leads us into the dimensions of this topic on leases, and it is a big topic. The size of the readings is over 100 pages in both of the books. The casebook and the ARPL, and I've led the charge a bit with ARPL, and then guided you, I hope, in best as I can, to read some of the case law in this area, some of the the more significant case law, rather than just going through all of the cases that are in APL, for example, to get that broad understanding, because what we're trying to come to terms with here is that this is an area, as I said, is governed by general law, but significantly now by legislation as well, the Property Law Act and the Land Title Act, but especially the PLA, specific legislation with regard to those other categories of leases that we just mentioned a bit briefly towards the end, retail shop leases and residential tenancy legislation, because our concern mostly is on the general law framework that mostly is governing commercial leases. A little bit on the background of where we came from in terms of leases and the leasehold interests. What are the different types of leases that have been identified, and how do we understand that? But then very much looking at the rights and duties of the two interest holders, the landlord and the tenant, or the lessor and the lessee. And those terms tend to get used interchangeably, in the various things that they are agreeing with each other and they are committing to, and the terms that are in the contract, in the lease. It could be an agreement to lease, but ultimately, hopefully, it will be a lease which will give a proprietary interest. But then there are implied terms from the provisions of the legislation. The knotty problem about assignment and subleases, and we can talk about the assignment of both from both perspectives. That is the assignment of the lessor's interest, which is the reversionary interest, that is the interest that the lessor keeps when a leasehold interest has been created, and an assignment of the lessee's interest, or a sublease. How is that different? How is an assignment of the lessee's interest different to a sublease, for example? So that's a bit of a knotty area. And then the remedies. Now, in terms of determining the lease or bringing the lease to an end and the remedies, this is really a bit where we get more into this contractual mindset. And then we need to think about, well, are we seeing the lease in property law terms, or are we seeing the lease in contractual terms? And this is really then what's leading us into that first question that I've posed today, the first problem question. Compare and contrast, this problem 14, compare and contrast the proprietary and contractual aspects of a lease governed by the general law of leases. Is it more appropriate to categorise remedies for breach of lease as proprietary or contractual? So, who'd like to chance their hand at this one?
Not me, because I just got confused by that.
Not you. You're volunteering not to volunteer. That's right. I accept that. I accept that.
I was really hoping someone else would be saying something, because I've been very lost on this particular question, as you would have seen. So to jump straight to the chase, contractual.
You're in the contractual juggernaut, Grant. Look, it's interesting that if you look at the history of leases, the villeinage idea that emerged in the 12th century, and then contract a few centuries later started to develop, and the idea of this interest that this tenant had, what was it, how could it be best explained, and then over time it emerged as an interest in land, recognisable as an interest in land. And what it was about it that characterised it as an interest in land was this idea of exclusive possession, that the lessee had a right to exclusive possession for the duration of the lease, or for the duration of the tenancy, as we say. And what that meant was that the owner of the land, who was the lessor, could not just come in willy-nilly and do what they like, when they like, because they say, oh, well, I own the land. This idea of exclusive possession meant that for the duration of the lease, the lessee had that right of exclusive occupation, if you like, and the landlord, the owner, could only get access, really, in certain circumstances, or by requesting access and giving a notice and so on. And so what you would otherwise regard as an owner's right with regard to land that was owned by them was curtailed and quarantined by this interest that the lessee had. And this was proprietary. And being proprietary meant that it was also valuable. And in a commercial situation, you can actually assign your leasehold interest. And in a business scenario, that can be valuable. So that, if we think about, for instance, if a person is, or an entity, and this can be an individual, but today mostly businesses are run by entities of different kinds, not individuals as they were historically, but individuals are still there. If an entity is running a business they have to run the business from somewhere, usually. You know, with e-technology, this is changing, of course, but usually things need to be physically situated somewhere to do something, to create goods, to create services, right? So on the one hand, you've got the business entity and the business structure of whatever it is the person is doing. On the other hand, you've got to have somewhere to do it. I mean, even with technology, you've got to have somewhere to have your computers and, you know, I mean, Amazon's got to have somewhere, for example, where it stores its goods and it then ships its goods, right? You can think of any sort of example of business, right? Now, if that entity wants to sell its business, right, and this is something that lawyers are involved in all the time in assisting their clients' sale of business, then there's value in the business which has been created, and you can sell and transfer the business and the value that's reflected in the business. But that business has to be run from somewhere. And normally there's value attached and goodwill, if you want to throw that idea into the mix, from where the business operates. And so the purchaser of the business also wants to most typically run the business from where the business has been operated. And most typically the business owner does not own the building, but is leasing the building. So what we need to have quite often, because if a business is sold during the currency of a lease, then there's not only the sale of the business, but then there's a transfer of the lease to the new owner of the business. So this becomes a valuable commodity, if you like, in a commercial environment. Right? So this is a proprietary interest that we can do things with. And as we've seen up until now, interests in land are valuable. Grant, did you want to say something?
Yeah, I was just going to say, touching on an earlier point that you made about the proprietary interest and exclusive possession, the right of re-entry and etc. In modern times though, and again, I'm referring to leases that I've seen before in a commercial, sort of from a commercial aspect, even down to that very fine detail as to the type of use, the fact that you have exclusive possession, under what circumstances the landlord may enter the property, all of these things that are what you're describing that are covered by that proprietary interest also seem to be covered in modern contractual terms, right down to the very, very fine detail.
Mm. That's right, because what's transpired is the dealings between lessor and lessee. Mostly we're talking about two business parties dealing with each other. Okay, so even if the landowner of, you know, the owner of the building, for example, the commercial building, isn't doing anything more than basically having this building, or sometimes they have several, as an investment, that is a business interest of theirs, right? So they are in business, and you know the business that they're in is investment and making money from investments and things. The lessee, commercial lessee, is a business as well. So basically, you've got two business entities dealing with each other. So it's most typical that they will negotiate on features of the relationship, and then that will be reduced to terms. And then in the first instance, what we will see is an agreement to lease. We will see an agreement to lease before we see a lease. And it's the lease ultimately, of course, that must be registered. But if it doesn't go beyond an agreement to lease, then the law will, as you will have seen from the material, will recognise that equity will recognise an agreement to lease and you know, give due recognition to that in terms of the rights and responsibilities of the parties under that. So it has, in the modern period, emerged very much in a contractual way, but there are still very clear proprietary characteristics here, an essential one, as I've been explaining. But the lease itself and the lease relationship is ultimately proprietary, or a property law relationship. But it has contractual characteristics. Now, when we get to the issue about remedies, which is what the question then proceeds to look at, and is really the focus of the question. The question then becomes, when there are problems between the lessor and the lessee, right, and they're in dispute, the question then becomes, what type of remedy best serves the interest of the lessor or the lessee? Okay. And that's when we get into a debate about whether the interest in the land is more valuable or of more value, or whether or not we're looking for a contractual remedy. And the contractual remedy, of course, which normally is provided, is damages, financial compensation for whatever loss that's been suffered. But the proprietary remedies are about the interest in the land, which goes back to the essential characteristic of exclusive possession. So depending on which party we're talking about, the lessor or the lessee, the lessor wants to get the possession back so that essentially the premises can be re-leased to another business entity because there's issues with this lessee. This lessee may not wish to give up possession even though there's issues because that's value. And so, that's where this debate comes from. Any thoughts or comments about that?
Oh, it's Aisha. I did make a comment today on Grant's post on this question on Moodle, and I think that I am a little confused. I get the idea. I understand the proprietary interest and the exclusive possession and all of that sort of thing, but coming down to the actual remedies, I thought that it would depend on the circumstances of the case, whether it was more properly, if the remedy was best being equitable, like say specific performance or something, or if it was best being damages. And I think, I just got myself quite confused over this question.
Yep. Any other responses to that?
Can I try and tie this into an example to see if I'm...
Please do.
Understanding where you're going.
Please do.
Okay, a lessee, for commercial reasons, may have invested heavily. There may be statutory obligations, whatever, that they've had to comply with, that places considerable value on the place that they are leasing. So for them, if you talk about a contractual obligation where in a court, if that can be satisfied through damages, then you may still lose possession. Whereas the proprietary interest and having the interest registered potentially gives the lessee greater protection to try and retain that interest in the property.
That's right.
Is that a fair?
That's right. But think about, can any of you come up with a practical example?
I can.
Yeah.
Well, what I had in the back of my mind when I was trying to give that example was a global logistics provider. They may have facilities airside at an airport. There is significant negotiations that take place with statutory authorities in terms of the operation and use of that facility. To simply be paid damages and kicked out of the premises would be disastrous from a commercial viewpoint, as opposed to, because it could take 2 years, 3 years to re-establish at another approved site and to achieve compliance. So in that situation, that commercial operator would fight tooth and nail to retain possession because it would destroy their business.
And going back to Aisha's point, where she was looking at damages, basically, you're looking at the common law remedy and then you look at equity. In contract, which you will have studied, then you would know that, of course, equity's response is when common law damages, or common law's remedy, is not adequate in the circumstances. That's when equity offers something different. It offers injunction or specific performance. But we're not talking here about saying, oh, well, you know, common law damages, financial compensation is not good enough, and we go there first because it's really a contract, and then we fall back to the position of saying, oh, well, maybe we'll think about the interest in land. This is actually the understanding of the lease is inverted. Assuming we've got a lease, by the way, and not just an agreement to lease, if we've got just an agreement to lease, then we haven't got a lease, okay? So an agreement to lease is just contractual. Well, if we've got a lease, then the relationship is proprietary, but it also has contractual features, and we can get access to contractual remedies. But the point is, as Grant indicates, if you start thinking about some examples within commercial situations, then the investment that because it's like thinking about it in commercial terms, the investment that the lessee has made in establishing the business in these premises, there's a lot of reason why, even when there are disputes and issues with the lessor prior to the expiration of the term of the lease, that they don't want just to get financial compensation for problems, and they certainly don't want to be turfed out of the premises because of what's involved in setting up their business somewhere else. And you can think of examples, and Grant's given us one, but you can think of others in terms of the nature of the business. I mean, think of even one of the cases we looked at, which comes up again in this topic, and that's the mercantile credits case. What was the business interest in the mercantile credits case? I'm sure we're familiar with the legalities of mercantile credits, but maybe we didn't delve into the business background. I mean, mercantile credits is actually about a service station. And
Shell,
yeah.
yeah.
And it's about a service station with relationship with a petroleum company. Now, wherever you happen to be sitting in this country, doesn't really matter for this point of view, there's been a waxing and waning for commercial reasons, really. There's nothing more to be said about it than that. A waxing and waning between whether or not the service station proprietor is an independent proprietor or whether they've got some sort of franchise arrangement with the petroleum company, or increasingly, as we've seen, the third alternative that's emerged in the last, I don't know, half a dozen years, is it? 10 years, maybe. It's half a dozen years, maybe a bit longer. That also you now have service stations basically representing or being a part of shopping grocery chains, Woolworths, Coles, right? So we've now got a tripartite scenario of the petroleum company having a business relationship with a grocery chain and the proprietor of the business, if that's the case. Or maybe the whoever's running the service station is no longer an independent proprietor, okay? But in any event, you've got the business entity, and then you've got this service station being sited on a piece of land. Now, it's an enormously, enormous undertaking to actually create a service station, even though they're everywhere, right? You've got to put huge, tanks underneath the ground to store the petroleum, all the electrics and all of that and so on and so forth. If you're the proprietor of the business and you have a commercial lease over that land to run the service station business, then that's enormously valuable to you. And it's also enormously commercially valuable that you could transfer the lease and sell the business. And that's in the past has happened. And there were some issues in the mercantile credits case around that and around the covenants, and mercantile credits has been helpful and relevant in property law in different ways and in different parts of our understanding. So that's where we're getting to. But the point is about this, contractual focus, is this really brings us back to the significant High Court case of Progressive Mailing House and Tabali. Because in Progressive Mailing House and Tabali, the court recognised the contractual orientation of leases in the modern period. So, for example, in the judgment of Justice Mason, he says, actually quoting from an earlier case, I think a Canadian decision, but anyway, part of his judgment. I'll just read this to you. It's coming probably not, I don't think it's from your APL, but I'll just read this to you. Just listen. It's only a short little section. It is no longer sensible to pretend that a commercial lease, such as the one before this court, is simply a conveyance and not a contract, not also a contract. It is equally untenable to persist in denying resort to the full armoury of remedies ordinarily available to redress repudiation of covenants merely because the covenants may be associated with an estate in land. Now, what's interesting is this idea that, the lease has a contractual nature and the parties should have access to the full array of remedies that are at their disposal according to the law of contract, in addition to what they might have access to with regard to, in terms of property law. And the other point that comes up in Progressive Mailing House is the idea of, well, fine, but what do we need to establish before we can get access to these sort of contractual remedies, financial compensation and so forth? And is it when we start moving in the direction of contractual thinking, then we have to ask ourselves, well, law of contract differentiates between the sort of relief that's available depending on the types of terms that have been broken or breached, right? And that, for example, in contract, that you need to breach or break an essential term or a fundamental term, but the more modern nomenclature is essential rather than fundamental. So breach of an essential term to be able to terminate the contract and also get access to common law damages, where the breach of a non-essential term will tend just to give access to financial compensation, that is damages. So what we're looking at here is really the extent to which that thinking and that mindset within contract also is relevant in this context of leases, even though they actually are about a property law relationship. And depending on what the parties want and depending on what is of greater commercial value to them at the end of the day, and the nature of actually what's been breached, will depend on what they want, whether they want to pursue contractual remedies or whether they want to pursue more this interest in the land and get it back or keep it. But what one needs to appreciate here is that a lease, if we have a lease as opposed to an agreement to lease, then if we have a lease, it is proprietary. It does create an interest in land. The leasehold interest is an interest in land in the hands of the lessee. It's characterised by exclusive possession, and that's valuable. But today, it's clearly contractual in character, and you can have access to the array of remedies that are available in terms of breach of contract as appropriate in various varying circumstances. Any reaction to any of that?
So prior to the modern contract, what was the contract prior to the modern contract? Was that simply the deed with terms in the form of a covenant?
Yeah, yeah. So, I mean, if we go back historically, then the lease was couched more in that way, and it was a property instrument. And so what you had access to was remedies and relief that property law gave you access to, because this was a property law relationship. And what the parties understood they had was things in relation to the land and the interest in the land, and what could be done and what couldn't be done in that regard. That's where, for example, and, the questions don't specifically touch on this, but something else does, that you're all looking at the moment. The various obligations that the parties had in terms of what the lessor and the lessee, what they had agreed to with each other. So for example, the various covenants under the lease, which are now regulated in Queensland, mostly, not entirely, but mostly by the PLA. So, for example, back on, from page 13 to 14 of the notes, the covenant by the tenant to pay rent, the covenant by the tenant to repair, the landlord's right of entry for inspection, the landlord's right of entry for non-payment of rent, the landlord's right of entry for breach of covenants other than the covenant to repair, and then the common law implied covenants with regard to quiet possession and not to derogate from the grant. These are all proprietary. They're not contractual, because they're about the interest in land. They're about the exclusive possession. They're about the obligations in relation to the use of the land and the upkeep of the land and the quiet possession of the land, and that the landlord can't do something that's inconsistent. I mean, the common law implied covenant not to derogate from the grant is that the landlord can't do something inconsistent with the proprietary interest that the lessee has. And depending on the situation and the nature of the premises and the building, then that'll work itself out in different ways. But those things are proprietary. But when we come down to the sort of remedies that the parties want, where there's a problem, then we start seeing more this idea in terms of contract and in terms of wanting financial compensation for breach of a term. And when we talk about then this idea of breaching the term, then we start to be starting to really be thinking more in a contractual way rather than in a proprietary way. So there we go. And there's also, as I mentioned to you before, there's the idea of assignment and subletting or subleases. Again, that links back to the proprietary nature of the lease, and that is that I can transfer my interest in the lease, my interest in the land. Both parties can assign. Both the lessor can assign their reversionary interest to sell the property. The lessee can assign, or there can be a sublease with the approval of the landlord, of course, ordinarily.
Can I add something on that, Michael?
Yeah.
Just with regard to subleasing and assigning and all that sort of thing, what happens where in a lease the lessee is not allowed to sublet and can't assign, and they're stuck in a lease for 10 years and say their business goes kaput? It's not so valuable then, is it?
No, but it would be, there's normally a provision, that the lessor can't unreasonably withhold permission to do certain things, including, for example, an assignment. But the issue also here is that, firstly, very typically, like in many areas, but this is true in this area, we very often have standard terms. So commercial leases, for example, there will be, just like for example, like in Queensland, not all of you are doing conveyancing, but in Queensland there are standard sale of contract documents that have standard printed terms on them. There are very typically, that's the case with commercial leases as well, with standard terms that are reflecting the law and reflecting the provisions of legislation to a degree, and then they can be modified and amended by the parties depending on their particular situation. Special conditions, special terms, covenants can be put in depending on the particular situation. So that's something that a lessee should be very careful about. And if you're acting for a lessee, then you have to look very closely at this issue about assignability and what are the provisions dealing with that, particularly if given the duration of the lease that the lessee is entering into. Because if it's a longer period, then clearly there's a significant commercial investment being made here by the lessee, and of course the willingness by the lessor to be prepared to grant a lease for that term.
I agree with you there. It's just I saw a lease yesterday where that was an issue flagged for me, where the special condition said that the lease was not able to, the premises could not be sublet, the lease could not be reassigned, and all of that. And I thought, ooh, geez.
But see, from a perspective of commercial practice now, as opposed to legal practice, lessors, of course, will try as much to push as hard as they can to get the balance tipped in their favour. So they don't want. They're entering into a lease with this party. They don't want it to be able to be transferred to another. They don't want this to be done. They don't want that to be done. The lessee has to push back against that, like in any negotiating process, so that the process is levelled up. Now, of course, in any business dealing, you can have an imbalance of bargaining power, or you can have a more balanced bargaining scenario, right? If I give an example in a retail lease situation, and this is not governed entirely, is governed by legislation, but important to remember that retail shop leases it's not a codified situation. So we have provisions under the retail shop leases legislation, but the general law of leases is still relevant to retail shop leases as opposed to residential leases that are really much more codified. Thanks for that, Grant. And in that scenario, you get different bargaining positions. So, for example, you can think of your local Westfield shopping centre or complex. We've got them, they're all around the country and they're overseas, everywhere they are. There's a very big difference, for example, between what I would call an anchor tenant, like variety store, department store, or grocery outlet, and of course some of them are all owned by the same group of companies. So if you've got Coles, Myers, and you've got Coles, and you've got Kmart, and you've got Target, they're all owned by the same group of companies, so that's interesting. That's another different dimension. But there's a very big difference between that type of a lessee negotiating with Westfield Holdings, who basically owns the shopping complex, to your little boutique clothing store or foot store or something like that. Very different in terms of the negotiating powers, and in terms of what they're getting in their leases, very different too. So the big anchor tenants could be getting 10-year leases, 10 by 10-year leases or whatever, whereas the scenario for the small commercial lessee is significantly different. Now that illustration, of course, is impacted by the retail shop leases legislation, but there is still in that area a continuing role for the general law of leases. Right. Very important, just on that issue, before we get to the second problem question, to distinguish between an assignment and a sublease. An assignment is a transfer of the entirety of your interest. So in the context of the lessee, an assignment is I'm assigning the whole interest to a third party. Whereas a sublease, I'm not transferring the whole of the interest, but I'm creating a secondary lease, and that sublessee, I'm then in a landlord-tenant relationship with the sublessee. So the lessee is a sub-landlord to the sub-lessee. I might be running a business let's keep it in a commercial situation. I might be running a business and I've got, there's sufficient floor space where I can sublet out a couple of the rooms to another business. So I now have put myself into the scenario of being a landlord, but a sub-landlord to a sub-tenant or a sub-lessee. But again, that has to be with authorisation or approval by the head landlord, if you like, right? Now, very interestingly, I've got a bit of a vested interest in this, but getting out of the commercial situation, and this is something that we'll just touch on in the last topic on social housing, that has been a scenario that existed in social housing in the various jurisdictions in Australia for a considerable period of time. There's been reform and change there. But so basically what you had in social housing was, and you had a head lease relationship between the government or the government housing authority or an entity that represented the government, normally a corporation, statutory corporation, and, for example, a social housing provider, maybe a community-based organisation. So they are in a lease, and often was a commercial lease relationship, and then the lessee under that commercial lease relationship would then let the dwellings to ultimate tenants, and then that relationship would be governed by residential tenancy legislation. But the first relationship was actually a lease, and so it had a head lease and a head lessor and a head lessee, and then effectively what one had was a sublease, but it was actually governed by different legislation because of the nature of the situation. So the idea of subleases is not uncommon in commercial situations and in other situations, but we do need to distinguish an assignment from a sublease. Of course, the lessor owner can also assign, that is, basically sell the building, sell the land, and transfer it, sell it to someone else, a purchaser. So that is an assignment, right? And if the purchaser is buying with a lease in situ, then what's being transferred is the interest that the lessor has. And the interest that the lessor has during the currency of the lease is what we call a reversionary interest. The interest that the lessor has to take back at the end of to take back the property at the end of the duration of the lease. And the lessor actually only has reversionary interest because the lessee has an interest in the land. It's proprietary again, see? So, complicated, people. Little bit complicated, but we have to navigate our way forward. Look, let's get on to the next problem question. Okay, so problem 14 is something for you to mull over and to reflect about in terms of the relationship between the proprietary nature and orientation of leases and the contractual features, particularly in the areas of remedies, but also, as Grant indicated earlier, even in the preliminary aspect in terms today of the negotiation, often seen more in contractual terms. And so this is really getting you to think about, if you like, the fact that these compartmentalisations within law are not as stringent as they used to be. That's the truth. Okay, and historically we often saw property law and contract, but increasingly these divisions are, they're not as clear cut as they used to be. And the law has to respond to the changing circumstances, in my view, so changing circumstances of the needs of commerce and of the social milieu, as we've explored in various ways in the course. And it often does that by looking at the armoury of remedies and rights and entitlements and says, well, how can these be utilised in this situation to best meet the outcome and best meet the needs within bounds? It's not an unlimited question, but within bounds. And that then often requires reconfiguration of our understanding of the categories of law and how they work together or how they are differentiated. It's a challenging square sometimes for law students, just trying to navigate their way through the maze. Yes, it is. That indeed, ma'am, indeed. Problem 15. Getting back to something that's a bit more nuts and boltish, but it's still got a few wrinkles around the edges.
Those are like perpetuities.
What's that?
It reminded me of working out the perpetuities and all that. And I was thinking I'd rather stick a fork in my eyeball. I don't do maths and, you know, that sort of, if this happens, this happens, this happens. I really don't do well here. Thanks
for that, Aisha, because I think that's an important point to make. And can I say, and I'm sorry I don't have a whiteboard here, but I'm actually thinking of getting a small whiteboard that I can actually use, and I'll try and get one before the course finishes, so we've got about 3 weeks left. In property law, I think more so than in other areas, the use of diagrams and timelines can be very useful. It can unpack information, and it just can give you a more spatial perspective on what's going on rather than just all of the text-based information. So in this scenario, in 15A, we know that we've got a relationship between L and T, a lease relationship. We know that who's the lessor and who's the lessee.
Well, L's the lessor.
It's good.
Okay, good, great. One down.
So L's the lessor and T's the lessee, but T is a what?
Company.
Precisely. Okay, which most typically they both are actually. So T is a company, and we know that companies can't actually work, through themselves. And very often when one is dealing with companies, because it's an artificial entity, and of course, I don't know whether you've studied company law yet, but companies can purchase property, they're a separate legal person, they can enter into contracts, there's no issue about that. But the problem is we don't know how financially secure this company actually is. We can do an audit, we can do a due diligence on it, I suppose. But often there is a requirement that something needs to be guaranteed. So in this case, that's what's going on. We have a lease between L and T. So the leasehold relationship is between L and T. All of the terms of the lease, all of the covenants of the lease, all of the implied covenants under legislation of the lease are either owed by L as lessor to T or by T as lessee to lessor. Very important to see that the lease and the terms of the lease, or the covenants of the lease, if we want to use that nomenclature with regard to its proprietary character, are between the lessor and the lessee. And of course, we know that some of those, critically, obligations or covenants include the covenant to pay rent, for example. Okay. Then we have this guarantee, which has been provided by who? Who's it been provided by?
By the director.
By the director. And the director is what? Just give me more information about what's the relationship between a director and a company.
Sorry, the director has the authority to bind the company.
As what? That's true, Lisa. But say.
Acting mind will.
But what do we say a director is on behalf of the company?
An agent.
Exactly, precisely. So the director is a very typical agent of the company, and the company is the principal in that this is very typically an agent relationship between the director and the company in terms of doing things. Okay. We know, of course, that companies can enter into contracts and whatever in their own name, or pursuant to or by their agents, including directors and whatever. In this case, it would appear that the lease has been executed and signed by the company, under its seal or whatever. You don't need to seal anymore, but in the company's name with the lessor. Now we have this guarantee by the director. What's the guarantee in relation to?
Performance of the lease, or executing the lease.
Okay, so guarantees performance of the, not executing, guarantees performance of the lease by executing the lease. Who's executing the lease?
The director on behalf of the company.
Exact. Good. Very good. So the director is executing, but on behalf of the company, but the director is also guaranteeing performance. Okay. And the lease is expressed to be made with L, its successors and assigns, which is very typical phraseology. What happens then? What does L do?
He transfers the reversion to R.
What does that mean? Very technical language. What does it mean?
He transfers his reversionary or remaining or reverting interest to somebody else. So
more simple. More simple. More straightforward. What is he doing?
Yes, assigning the lease.
More simple.
Selling the property?
He's assigning his interest.
That's it. Good. So he's selling his interest, right? Which means that where there is a lease on foot, if he's selling his interest in the property, where there is a lease on foot, then of course he's also assigning the reversionary interest that he has as lessor under the lease. Right? So that's a technical language with regard to that. And then, because the transfer is referred to, right? And the transfer, what happens to the transfer?
Registered.
Registered. What does that mean?
It means that it is a recognised interest at law and it is protected.
Registered under what?
The LTA.
Right. So therefore, what sort of a lease is? What do we have now?
Legal lease.
That's an indefeasible.
Right. We have basically there's a sale of the property, and that's been the transfer that has been registered, and that means that we have a new owner of the property, Torrens Land, and they have indefeasibility of title. Right? Now the question here is that when the transferee when the transfer is registered, on registration, as we know from our earlier studies, Bresfar and Wall et al., that on registration, the transferee gets the benefit of indefeasibility. Now,
subject to registered interests.
Subject to registered. Thank you, sir. I was waiting for that. Subject to registered interests. And if the lease has been, is there on the title, then of course it is an encumbrance on the title. Now this question really goes to the issue of if this guarantee that's been made, is it a covenant under the lease, and does it get the protection of indefeasibility under the lease or not? What do you think?
If it touches the land, it does.
Touches and what else? More.
Touches and concerns.
That's it. I'm always concerned about everything, you know that. So that magic phrase, right, touches and concerns the land, okay? And that's also subject to oversight by the Property Law Act. There is provisions there. Does it touch and concern the land?
Rent does, because section 117 of the PLA provides that rent is one of the lessee's covenants that run with the land.
That's very good, thank you for that. But the question is, are we looking at a rent covenant here?
Generically, isn't it implied? Because if the guarantor guarantees performance of the contract, doesn't that mean he's guaranteeing all covenants?
But is a guarantee the same as a covenant to do something? Or is it separate?
Don't know.
I'm not sure. I thought there was an implied covenant to pay rent under, I think it was 105 or something. So I'm not sure about guarantee.
Covenant to pay rent, no problem with that, right? No problem with the covenant of rent running with the land, in the sense, not chasing the land, but touching and, let's use the right language here, touching and concerning the land, right? No issue with that. That's good, all good there. And if this is about a rent covenant or a covenant to pay rent, that's not an issue. It touches and concerns the land, it runs with the land, and it will bind the transferee. No issue about that. The question is this a covenant to pay rent, or is a guarantee of performance something different?
If the guarantee is registered against the title, wouldn't that be, isn't that what a covenant is? Isn't a covenant just a registered condition?
What did Barwick say in Mercantile Credits about registered covenants?
I can't say without going back to the actual case.
Didn't Barwick in Mercantile Credits talk about different types of covenants, and that only covenants that went to the estate in land were actually covenants that attracted the indefeasibility under the Torrens Act on registration? Do you remember that? Just say, you can just say yes at this point if you want.
I'll say no.
Okay, yes.
Universal, yes, okay. If you go back and have a look at Mercantile Credits, and Mercantile Credits is referred to in these topic 7 notes as well, by the way, and discussed in the materials for leases, he does differentiate. Right now, the question, and you might remember if you went back, and actually, Aisha, I think you posed a question on this back when we looked at indefeasibility of title, and that is...
Some time ago, Michael, wasn't
it is a little while back, but you know, one has a memory about these things. Particularly interesting questions. I never forget interesting questions. Right? And seeing that all my students always ask interesting questions, there you go. Right? But the point is that if this is a covenant that touches and concerns the land, runs with the land, that's no problem, and it will bind the transferee. But what other type of covenant, if you can cast your mind back, could we characterise covenant? If it doesn't touch and concern the land, how else might we characterise a covenant? Can you remember?
Well, it's an agreement to do something.
Yeah. Who is doing the agreeing?
The director on behalf of the company.
The director. Who's the lessee?
The company.
Oh. Does that make a difference? Or?
So does that mean
relates to the person with the interest?
Say again.
The covenant relates to the person who has the interest in the land. The director, the lease is signed by the company, even though he's signing on behalf of the company. So the company has the interest.
Yes.
He doesn't have an interest. So technically, wouldn't that imply that he cannot covenant?
Oh, no, he can covenant, all right. No problem. I mean, covenant is just an important term. That's what we mean by covenant, right? And in this context, it has proprietary implications. But the issue here is, could you say that this guarantee that this director is providing is a personal covenant?
Yes.
Oh, who said that? Who? See, now you're remembering your. But it was in a different context. What you said earlier was in a different context. Well, the point you raised, a few weeks back when we looked at that was in the context of a mortgage, and you were looking at the personal covenant to pay. You might remember that question.
I remember now.
Yeah,
Thanks.
but that was in the context of a mortgage, right? So we need to get this. Mortgages and leases aren't the same thing. But if this can be characterised as a personal covenant by the director, it will not touch and concern the land because it's personal to the director.
Yeah, that makes complete sense. Now you've
Right.
said that.
Right?
Huh.
Right. So if it is personal to the director, it does not touch and concern the land, it does not run with the land, and it does not attract the indefeasibility on registration of the lease. Right. Now, this raises another challenge for us. And this actually takes us back to the issue of what I call the challenge of the Bursal and Berger Brothers case. And you might remember that case, and it was even mentioned in Leases, actually, right at the beginning of the discussion of Leases. That's tossed up. Tossed up, or is it tossed up? Anyway, it's there, and that will come. We'll spin back onto the Bursal and Berger Brothers case too when we look at easements. Which I'm thinking of doing next week. Actually, I'll explain that to you before we finish. But that was about the registration, you might remember, of an easement. And there was debate there between, well, are we able to just look at what's actually on the certificate of title, or in Queensland we talk about it as the indefeasible title and the particulars there, or do we have to look behind that and then go and examine the documents and examine the actual instruments that have been registered to work out what that means? And there was discussion there about, well, normal practice would be, conveyancing practice would be, yes, you would do that if you were put on guard, right? So in this case, do you need to go and examine the lease document, the lease, to see the nature of the covenants and so on? But even having done that in this case, so that's another dimension as to whether you should do that or need to do that, but even doing that in this case doesn't necessarily answer the question of whether this particular covenant touches and concerns the land and therefore gets the protection of indefeasibility. Arguably, it is a personal covenant by the director. And be careful here not to confuse the fact that an undertaking to guarantee performance is not actually one of those recognisable covenants that are implied under the legislation, or if they're expressly agreed to between the parties. But, for example, the wording of this to guarantee performance, that would be performance of the entirety of the lease, is not a covenant to pay rent. That's different. And, of course, that runs with the land. But, as always with these sort of scenarios, it's, the answer really is it depends. That's the truth. It depends on how it's expressed, and if it's framed in a way that allows it to be seen as touching the estate of the land, then it will. But if it isn't, then it won't. And you need to really, I suppose, in truth, you need a bit more information here about that. And the question is intended for you to tease out those dimensions in terms of its enforceability against the registered transferee, who has the benefit of the transfer being registered of the land and the reversionary interests where the lease was in situ. Right. What about B? In what circumstances will a court refuse to grant relief against forfeiture for non-payment of rent? Nice little simple one to finish with, eh?
Out of the readings, to me, there was a shopping list of reasons as to why a court may not grant relief against forfeiture.
Can I just stop the shopping list before? I've seen the shopping list, and that's insofar as as far as the shopping list goes, that's all right. But I want you to think more fundamentally here about what's in contest. So relief against forfeiture for non-payment of rent. Who's not paying the rent?
The lessee.
The lessee. Right, or the tenant, lessee, right? And who's seeking forfeiture?
The R. It's no longer L. R is now C.
Well, R, if you go back to R, yes. So, but the lessor, right? Lessor is seeking forfeiting what? What is it that the landlord wants forfeited?
Lease.
The lease. The lease, exactly. The lease. The leasehold interest that the lessee has because of non-payment of rent. Rent being considered to be, important, obviously. Notice it's not the characteristic of feature of what is a lease. So the payment of rent is not characteristic of a lease, but it's, in commercial terms and and the law reflects this. It's an important, very important aspect of the reasons why the property is being leased. So basically, if we reinterpret that technical legal language, what's happening here is that the landlord wants to forfeit the lease, get the property back, because the lessee or the tenant has not paid the rent. So, in terms of relief against forfeiture, who's getting the benefit of the relief?
The tenant?
Yeah, the lessee/tenant. Right. Now, this question then is saying, when will the court intervene to protect the lessee where the lessee hasn't paid rent and basically the landlord wants his property back? Because if the lessee or the tenant hasn't paid his rent, well, isn't it fair enough for the landlord to get his property back?
Isn't the general gist of it that if the circumstances are relatively minor, if the lessee is able to demonstrate that they are able to make good the lease, to catch up the past payments, to pay any costs, to basically put the lessor in the same position that they should be in, all good and well.
Sometimes. Again, it depends on the circumstances. And as you've referred to in your response, Grant, there are provisions within the legislation dealing with relief against forfeiture. But the truth is that the idea of refusing to grant relief is where, if if the court refuses to grant relief, which interest is the court protecting or siding with?
The lessor.
The lessor, the owner, right? Now, why would the court, or what would be the reasons why the court would do that?
Because the courts don't want to interfere in contractual terms that people have voluntarily entered into unless it's absolutely necessary.
I was going to say because the tenant's done something. I noticed there are a couple of cases. One of them was where the tenant was using, and I don't know if I'm on the right track here, but where the tenant was using the premises for immoral purposes, or there was another one where the tenant had exposed the premises to uninsured.
What can you be suggesting, ma'am, about immoral purposes?
Very naughty tenant.
Oh, right. You mean what?
Conduct.
An aquarium business. Is that what you?
If you like.
Look, I mean, we can laugh about this, but you know, some of that case law goes back, and of course, you know what they're talking about is prostitution, right? Let's be open about it, right? But this is an interesting thing, the law. Okay, so some of that case law goes back to a previous period of a different set of social circumstances. So this is where we've got to exercise care. I mean, you're on the right track, absolutely, Lisa. Let me just say that. So where the issue really goes to the risk, if there is a higher risk being put upon the landlord here in terms of the use of the premises, that might go to reputation, or it might go to, impression, that is something where then the court will intervene to protect the landlord and not grant relief to the lessee. Where, you know, the landlord is seeking forfeiture, that is, wants the lease forfeited, wants the property back, right? And the relief in this situation where there has been non-payment of rent is something that is accorded to the tenant or the lessee, right? But in this area, and that is one example, it is, you know, public policy intervention on the basis of, you know, immorality or whatever. But we have to understand that that's not the same today as it was 20 years ago or 30 years ago or 40 years ago, right? For example, it's all very well to see that example sitting in the property law casebook or whatever, but in some parts of this country, prostitution and running those sort of businesses is legalised. So the idea about morality is it's a slippery canvas. I mean, one of the more interesting scenarios, I think, at the minute would be, you know, and this raises a whole lot of other issues, but just from a property law perspective, because, you know, we're absolutely obsessed by property law, aren't we? If it was discovered that the tenant was involved in some sort of terrorist activity, for instance, and in the very current climate, doing things with regard to maybe supporting initiatives in other places and these sorts of things. So always looking for those examples that update the reasons why the court will intervene. And the truth of the matter is here, we're really looking at, a court of equity or exercising equitable jurisdiction to give justification for why the landlord needs to be preferred so that relief against forfeiture will not be forthcoming. So again, it's getting you to look at the competition between the two primary interest holders here in the property, the landlord and the lessee, or the landlord and tenant, lessor or lessee. But where and upon what basis will the court intervene to prefer one interest or the other? And there was never an absolute answer to that. And it needs to be understood against the background of how it's intervened in the past or how it's got involved in the past. And yes, I acknowledge Grant's point about, some reluctance to interfere in private dealings and negotiations and so on. But where there are good policy reasons, the court will always do that. But understanding how that transpires in the current environment, not in the 1960s, not in the turn of the century, not even 20 years ago, but in 2014. What's going on? All right? And so you're looking for examples and how this works given how we function and how we do things today and the sort of business interests that are there, for instance. Right? And even though some things get characterised in non-business terms, there's often a business dimension. I mean, there's a current challenge, I think it might have been resolved, but current challenge before the High Court with regard to the bikie legislation in Queensland. I'm sure some of the premises from which they operate, there's a business activity happening there. So there is a business element to that, and there will be, leases underpinning, their operations. I mean, these are under the surface of all that other political debate about things. There are these dimensions of legal structure as well. But how do these more established and sometimes a bit arcane structures of law, how do they adapt and relate to modern circumstances and modern conditions? For property law, I think this is sometimes a big challenge because a lot of it is anchored in conditions of life and conditions of business that hark back to earlier times. It has to be relevant in the current period. It has to be. All right, people, we're at 3:24. I'm going to sort of bring it to an end there, but I just want to, a couple of points I just want to say just before I close for the benefit of those who listen to the recording, but also for yourselves. Just a couple of things. One is that next week I'm giving serious consideration to maybe having two tutorials, and I'll give you some. I'll put up some information about that early next week, so that I want to try and get the course finished on time by week 11. And I'm also conscious you've got the moot assessment coming up in week 11. Finish the course by week 12. Moot assessment week 11, and I want to cover the topics that are relevant for that. So I'll just give you some more information to that. Yes, okay, it's good. And the next point is with regard to the moot assessment, just say for the benefit of everyone that the scenario that I've provided applies to both options. It's pretty clear now that I think almost everyone is doing option B rather than option A. I don't think I've had anyone put their hand up for option A yet. Well, that's fine. I've basically given you those options because I understand people's different circumstances. But for option B, I want you to approach it from the perspective of one of the parties, primarily. So I want you to do it as if you are preparing written arguments that you would hand up, right? It's not an assignment in the sense of analysing all the legal issues from both sides, right? You're focusing on one party as opposed to the other, but that in part anticipates a bit what sort of response you would get on the arguments that you're presenting. Now, I think there's a sufficient amount of material there and issues from both sides for you to do that, but that's the focus. I've responded to a few questions on that. I'll put up another Moodle post just making that a bit clearer. Because what it really is with option B, it's a replication of what you would be doing in the oral moot, but you're not actually just presenting the oral submissions, but you are presenting written legal argument. It's not just a debating of the issues. And so that necessarily is about, well, what arguments would you be presenting if you're representing one side as opposed to the other? But there does need to be a little bit of anticipation in that discussion. What do you believe the other side would be saying to be challenging the propositions you're putting forward or the argument you're putting forward, representing your particular client?
Yeah.
Does that make things clearer?
Yes, it does. Thank you. Now, I understand we both submit the one document.
One document.
But which one of us submit it, or do you want us both to submit
No.
it?
Thanks for that question. It's a good question as well. I'm not worried about who submits the document, so long as both names of both partners are on the document and then you can just tell me we're submitting it and I'm submitting it on behalf of, and that's no problem. Okay. I think in this situation that I'm happy just for people, I think the most efficient way is just for people to email the documents to me. I don't think it's really necessary to set up in the Moodle system, but if people think that's a more easy, straightforward thing, that's easy for me to set up as well, and it can be done. You can set it up. You can submit it through Moodle, but otherwise, happy just to have them received by email. Yeah. So just make sure both names of both partners are on the document, and one submits, and just tell me that, and tell me who you're submitting on behalf of, you and your partner. I've certainly made a note of those. Everyone that's emailed me so far, I've made a note of who's partnering with who's doing option B. So I've got a list of that, right? Any other questions?
I have one, Michael. Could you tell us when the quiz 1 results will be released approximately?
Yes, they'll come back next week.
Okay.
Yep.
Thanks.
I'm hoping by early next week. That's my hope, but next week absolutely. Yep. They're well in train. And just on the issue of the quiz, I understand the important to turn those things around. I mean, it's I think a couple of weeks, 2 weeks on Monday. So yeah, the early part of next week. That's I should have them back to you by then. Okay. All right. Are we done, people?
Yes.
All good so far?
Yes.
Sort of. All right. Okay. Okay. So that's clarification provided on the mood assessment. I will put up, some further brief guidelines on that, just on a Moodle email to you. Quizzes will be back next week, and also just foreshadowing, I'm prospectively thinking of a double tute next week, but certainly not together. I'll space them. I'll probably have the usual one at 2 o'clock, and then I'll run another one in the evening. It's just impossible. The sort of material we're covering, we can't do double back to back. That's just impossible. They'll both be recorded. If you can't attend the second one, that's fine. But just conscious that we want to get through things so that it doesn't all pile up at the end, and also that we've covered what we need to cover for you for your assessments, particularly the mood. And then just the last thing. Sorry to say that. To say that this is week 9. So toward the end of next week, you will have information about the final assessment, and that will be posted up onto the Moodle website for you as well. Yeah. Okay.
Thank you.
Oh, good. All good. Okay.
Thank you.
All right. Bye, guys.
Yeah.
See
Good night, everyone.
See you. And enjoy Landlord. Enjoy. Bye for now.